Hi, good evening everyone, and welcome to this Society of Labour Lawyers event on private renting standards. Thank you so much for coming. We've got three brilliant speakers this evening. We've got Karen Buck MP, Professor David Ormandy and David Watkinson. And just to briefly introduce them, Karen Buck, for those who don't know, is MP for Westminster North and has the front bench social security brief, and is also chair of the all-party parliamentary group on legal aid. She was the driving force behind the groundbreaking Homes Fitness for Human Habitation Act 2018. And I think the remarkable thing about Karen is that she's not a lawyer, let alone a specialist housing lawyer, but she's committed herself to understanding and improving this difficult and technical area because of the good that housing law can do for her constituents. And I'm sure that that's a sentiment that a lot of us here will recognise and commend. The next speaker will be Professor David Ormandy, and David is an eminent public health academic and a leading expert on housing conditions and health. His expertise spans the disciplines of law and medicine and public health, so he's uniquely well qualified to talk to us about housing standards and health, and also has a great deal of practical experience, having advised and worked with the World Health Organization and local authorities and central government on housing standards. And he's going to talk to us about enforcement in other jurisdictions and this jurisdiction to see what we have to learn. And then lastly, we'll hear from David Watkinson, who has decades of experience of legal practice behind him. He's a retired barrister and has argued points of housing law at every level, from the county court to the European Court of Human Rights. And David will tell us about the role that international law can play in housing standards. There'll then be time for questions. Please do send me any questions you have in advance via the Q&A function or via the chat function, and I'll put them to the panel. So without further ado, over to Karen, if I may.
Thanks very much for that introduction, and it's really nice to be able to do this. In fact, it's the first time, I think more or less the first time I've been able to talk about this for some time, certainly since the legislation came into effect for existing tenancies, as opposed to new tenancies that came in a year before, and to kind of get a chance to revisit some of these issues. So I thought what I'd do is just talk a couple of minutes about kind of where the Fitness for Human Habitation legislation kind of came from, and a couple of minutes about its progress through Parliament, how we kind of got it through Parliament and why. And then a little bit about just kind of some of the wider contextual issues that I've been dealing with and that preceded and also ran alongside the passage of the legislation, and one or two thoughts on what else we need to do to make it work, and above all, because it doesn't matter in itself, make conditions better for tenants in all sectors, but the private rented sector obviously having the worst conditions. So it kind of shouldn't be a surprise to anybody, and wasn't really a surprise to me, that I ended up taking this particular piece of legislation forward when I got the opportunity, because Paddington and North Kensington, which is what my constituency was called between 1997 and 2010, it then became North Westminster, probably more than any other constituency in Britain, has an association, an unfortunate association with squalor and bad housing. And I mean, you can find this actually if you go back and look at the booth maps of poverty, which is still pretty kind of applicable, pretty synonymous with where a number of our issues are now. You go back to Dickens talking about some of the worst poverty that he saw, which was around the Marylebone Road, now the Lisson Green Estate. Lisson Green Estate, of course, where as featured in My Fair Lady, as the origins of our heroine, but also more particularly, and also it has to be said, the kind of starting ground for many of our the first generation and indeed the second generation of housing associations, which grew up in response to squalor in the private rented sector. So, initially Octavia Hill, whose starting ground was in my area, my neighbourhood, and then the next generation, the Notting Hill Housing Trusts and Paddington Churches Housing Associations that grew up for the second wave. That second wave was very much in response to the two great notorious names of private landlordism, which was Peter Rackman and Nicholas van Hoogstraten, so both of whom were operating in Paddington and North Kensington. So as a kind of inner city area, it has been at the forefront of bad private sector housing conditions forever. And it still has the largest private rented sector as a proportion of housing stock in Britain, in Westminster, which includes the top end of the market, the kind of penthouses in Marble Arch, and some of the worst conditions as well. And I'll kind of come back to why that's a particular problem, and not just a general problem. So. When I got a chance to be featured in the private members bill, I wanted to do something about housing conditions. And obviously, as many of you will know, private legislation is quite constrained. You can't spend money. You can't do an eradication of child poverty bill, which would be nice. You have to you can only spend at the margins a small amount of consequential costs, and so you're quite limited in what you can do in legislative terms. I'd also been doing, which was relevant to this, and maybe we'll come back to this work, for some years previously, been working with Stephen Battersby. Some of you will know Stephen, the former chair of the Chartered Institute of Environmental Health, and an environmental health officer, where we've been doing freedom of information inquiries to establish what local authorities were doing in terms of enforcement under the Housing Act, and particularly the enforcement of the Housing Health and Safety rating system. We did a succession of these FOIs that gave us some very disturbing feedback into the extent to which local authorities were using the powers that they had in terms of enforcement. Now, I don't use this as a stick to beat local authorities with at all, but the low level, I think it was 1%, our last survey of properties, the number of enforcement would have been equivalent to 1% of all properties with a Category 1 hazard. And one local authority was Newham, was carrying out virtually half of all of the assessments of enforcement action in the entire country. So we knew local authorities were not doing the work that we would expect them to do, given the scale of the challenge in the private rented sector. And we also knew that some of this is down to resources, and those surveys were all against the background of squeeze on local authority spending and a reduction in the number of environmental health officers. But actually the sheer patchiness of the responses also showed that there is an issue about political interest and political will as well. And even within limited resources, I think it's important that it's possible to drive forward improvements if you want to. So taking that all together, and taking also a very particular issue, so I've been dealing with kind of bad condition stories in all sectors ever since I've been a member of Parliament. But there was one particular estate in my constituency, a lovely estate, actually, an award-winning estate called the Hallfield Estate, where in the later years of the last decade, I was getting a tenant after tenant after tenant after tenant coming to me, talking about the level of excess cold and the consequences of that excess cold that they were living in, not because of disrepair, and not because of bad management of the estate, but because the physical design of the estate, and particularly the way in which ventilation and the concrete walls and flat roofs intersecting on the estate made it absolutely impossible without a fundamental redesign for those people to live in decent conditions. And it was so bad that I was experiencing families who were living in one room of their flats and sealing their properties with paper, tin foil, and plastic in order to try and insulate the rooms, because they were unable to heat their rooms. And we had a dedicated interagency public health team working purely on that estate, but without dealing with the design problems, which were expensive, and therefore people were reluctant to do it. Very little we could do. So I then came across our two lawyers, Justin Bates and Giles Peaker, who were then key players in the Housing Law Practitioners Association. And by chance, I've been talking to particularly Initiator Giles about kind of some other housing issues, when my first chance at the private members ballot came up. I spoke to him about it and said, you are a housing lawyer. I want something about housing conditions that clearly can't spend money, and I want it to be neat. I want it to be something that can't be can't be easily kind of amended and thrown out, as any of you who watched private members legislation will know. And he went away to talk to Justin, and they came back with a proposal that the Law Commission had first made in 1996, which was the fitness proposals, which amended the Landlord and Tenant Act to ensure that tenants would have lifted the rent limit, which had not been amended for 40 or 50 years at that stage, which meant, because of that low rent limit, meant that tenants were not able to enforce on their own behalf if their property was unfit to live in, not because of disrepair, but because of issues of unfitness, and that could be design factors. It could be the absence of heating, the absence of ventilation, the way the property was designed, dangerous stairs, a whole host of other factors that would lead to risks, that would lead to mold and damp, and all of the issues that we're so familiar with. I loved it, thought that was a brilliant idea, took it forward, despite our best efforts, and it's the very succinct and neat proposal. It was talked out the first time. I thought that was probably going to be our shot, but fortunately after the 2017 election, I got placed again in private members ballot, higher placed, and some other things changed as well, because governments don't like passing private members legislation, sometimes for ideological reasons. The people who would talk out private members bills year after year after year in Parliament were ideologically disposed to block any legislation, anti-legislation. But governments like to control their own legislation. Obviously, they do, of all colours, really, and don't like private members bills. But there was a hung Parliament, so that made a difference. So government couldn't count on a majority. And of course, a week after the 2017 election, Grenfell happened. Also, was in my previous constituency, and I think Grenfell changed the mood, not as quickly now as we know 4 years on as everyone was expecting, but changed the mood a little in terms of regulation, and in terms of tenant empowerment, and the kind of preparedness to consider giving tenants their own voice and their own routes to seeking redress. So we got, after some time, the blessing of the government to proceed. Doesn't always automatically still mean you can get through, but makes it much more likely. We did get through, and the bill passed into, we got Queen's, we got the royal assent in just before Christmas in 2018, came into effect for existing tenants 3 months later, and for new tenants rather, and then for existing tenants the year after, applicable across all sectors. And what the legislation does, of course, is allow tenants to enforce on their own behalf with lawyers, or not even necessarily through a legal, not necessarily with having legal representation, but to enforce on their own behalf where their property is unfit. And not to have to rely upon the local authority taking enforcement action for the reasons that I've referred to, the very patchy and inadequate level of enforcement local authorities have been doing for many years. We don't know, and I was asked this question just before we started the seminar, the full scale of how it's rolling out, partly because the application to existing tenants came in literally as COVID lockdown occurred, and I suspect that what might have been rolling during those months hasn't. But I do know anecdotally of cases where this has been used and used by lawyers and by others against landlords of different tenures. And cases have been settled and a successful conclusion brought through the legislation, and that pleases me a great deal. As I always said, the success measure is not how many cases go to court. The success measure is whether it makes a difference. So that's great. But what we also know, and I'll finish kind of on these points. And in fact, the COVID experience, I think, kind of highlighted even more starkly the sheer impact of bad housing conditions, including overcrowding as part of the housing conditions on public health. And there was some focus on that during the early days of COVID. And it was interesting for those of you who didn't know that yesterday, Matt Hancock actually said, in response to the piece of work that ITV have been doing on bad housing conditions, not just in the private rented sector, that housing would be one of the priorities for a public health approach in the post-COVID world. Now, imagine my surprise to some extent, but also above all, what will be delivered. I mean, they're fine words, but that and Marmot and the Marmot Report and other discussions that are taking place about the scale of health inequalities and how housing feeds into that is, we're beginning to understand the scale of the problem, the impact of the problem, and the need to put housing health and housing standards as part of that agenda. But at the same time, we have got several things going in the opposite direction, and I will finish on this point. One is that I am really clear and can see with my own eyes in real time the extent to which the most vulnerable people are increasingly being housed in the worst of the private rented sector, as the private rented sector has been growing. It's slightly less so now. But I mean, this was something that Julia Rudd kind of identified in her report a couple of years ago. And it is kind of like visible to the naked eye that with discharge into the private rented sector as a kind of key factor of housing policy, with the growth of temporary accommodation, separate category, but absolutely diabolical conditions that I see, and just the squeeze on local housing allowances, and the inability of the poorer tenants to exercise the kind of choice and exit within the housing market, I think is a growing problem, because with less choice comes less willingness and ability to take risks in terms of landlords, and despite some protection against retaliatory eviction, there are more than one way for landlords to behave, and the fear and anxiety amongst powerless tenants, many of whom have been subject to frequent moves in the first place and don't want any more, is a real problem. I mean, the other problem is, of course, the issue of access to advice, advocacy and representation, the battle for legal aid that we've been fighting for a number of years, and the growth of advice deserts. So people who would be perhaps empowered to take action or have action taken on their behalf can't even get to first base in terms of being able to do that. So I think there are real, and in some cases growing, challenges and pressures, despite the positive progress that I think we made with the recognition on the one hand and with the framing of the legislation on the other. So I'll finish with that.
That's great. Thank you so much, Karen. And I know you had a piece published today about advice deserts, and I'll put that in the chat for everyone. And as you say, we were talking before we came on the call about how the new bill, the new act is bedding in, and those of us in practice can see it's made fighting squalor so much easier. Can I pass on to David Ormandy then, please?
Okay. I don't know the audience whether or not you have a lot of knowledge on housing, health and the legislation, but forgive me if I become boring. One of the things that undermines some of the things that Karen was talking about is assured short hold tenancies. These are now the most common form of tenancy in the private rented sector. And usually the landlord gives 6 months tenancy, may give more, but why give more? Why bother? Just stick with the 6 months. One of the important things about assured short hold tenancies is that they do not guarantee renewal. Renewal is at the whim of the landlord. So if you upset the landlord, and you become somebody who complains a lot, maybe the landlord won't renew the tenancy or offer you a new one. All tenancy agreements place obligations on the landlord, including the ones that Karen talked about. And the tenant can take action for breaches of those obligations. The main ones that have been around for a long time are the state of repair and proper working order of a heating system, and those aspects of the dwelling. So the question really then arises, I should mention a couple of other things, that as well as repair, the gas appliances should be inspected and tested every year. And they're bringing in one on electricity as well, electric installations, which should be tested every 5 years. But there are these things that undermine it. One is, will the landlord renew the tenancy? If you're there and you've moved in and you've got 6 months, do you unpack your stuff? Can you call this a home? I like to differentiate between housing, dwellings, and homes. Homes are what we create when we move into a house, a flat, or whatever. The building is the housing, the dwelling. And as Karen also mentioned, legal aid problems. Can you get legal aid to take your landlord to court? Right. So that's a very brief and only outline summary of some of the problems relating to private rented sector tenancies. One of the things that has been around since 1900s, pre-1900s, was a duty on landlords to take action to deal with unsatisfactory housing. Initially, this was whatever the local authorities thought was unsatisfactory. And that duty just passed on from act to act, from legislation to legislation, and it is now in Part 1 of the Housing Act 2004. It's all very well placed, the duty on local authorities, but there is a shortage of environmental health officers, as Karen mentioned. So many local authorities haven't got the staff to deal with environmental health, which is not just housing, but it's all sorts of issues relating to threats from the environment. So housing is a complex subject. Right, that's just a brief summary of that. Moving on to standards. The Housing Fitness Standard, was, which was the first national standard, was introduced in 1954. And it was probably based on health principles, but it was building focused. So it didn't talk about the threat to health from dampness or disrepair. It talked about the building, the structure, the facilities that were available. And over the years, since '54, the health principles got forgotten. So what you've got is something that maintains the building and can deal with problems that do not threaten health, but actually maintain the owner's property. So you can deal with, for example, open jointed brickwork. Well, that doesn't threaten health, but it does reduce the value of the property. And if value is important, that's the interest of the landlord. But that fitness standard was first suggested by the Ministry of Health in 1919. And the one that was introduced in 1954 was a slightly weaker version, but nonetheless it shows, or the fact that it came from the Ministry of Health shows there was a health interest in maintaining houses in a satisfactory, if not healthy condition. The government did commission in about 1996 some work on reviewing the fitness standard as it was, the one that was introduced in 1954, and 10 years work by various bodies, including the university where I am, which is Warwick University. And in 2006, the Housing Health and Safety Rating System was introduced. A really snappy title, that one. Anyway, the system was shifted the focus from the building, the structure, the facilities, to threats to health and safety. This, and it was, if you like, the effects of defects. So if a defect didn't threaten health, that wasn't important. What was important was anything that threatened health. And that can be relatively minor. Like a loose window catch could mean a small child could climb out and fall out of the window. And if that's on the 5th floor, that is very dangerous. Now, the principles was shifted into 4 categories. They dealt with the protection from the physical condition, protect psychological requirements of occupiers, protection from infection and protection from injury. That wasn't new. In fact, the American Public Health Association proposed similar things under the same sort of headings in 1939. So none of this is new. It's just that we haven't done much about it, anything about it, until 2006, when the rating system was introduced into the legislation. One of the problems with the rating system is not the system. Well, people do argue that it's difficult to understand, but the main problem is the procedure for applying it. The local authority have to arrange for an inspection to be carried out, so to contact the landlord. And if there are problems associated with health or safety, then the local authorities is supposedly under a duty to take action. And that action means serving a notice, a formal notice requiring works to be done within a specified time and specifying the works. And that should go, included with that should be a statement of reasons. So not only does the local authority officer have to prepare the notice, well, do the inspection, then prepare the notice, has to come up with a statement of reasons. The whole procedure is bureaucratic, complicated, and time-consuming. Everything that a local authority officer doesn't want. And if there's a shortage of environmental health officers, local authority officers, then hang on a minute, I'll just chat to the landlord and see if I can persuade him to do this. Right. Next thing is, there's a right of appeal. So if a landlord receives a formal notice, there is a right of appeal against that notice or the content of the notice or the time given. And as soon as the appeal is lodged, the notice is suspended. And it just stays there until the appeal is settled. While this is going on, the tenant is still living in an unhealthy house or dwelling. Well, that doesn't make sense, really, but there we are. That's what happens. Some of the work that I have done has been looking at, this was through the World Health Organization, I got to look at what happens in some other countries. And one of the countries I looked at was France. Tenancies there are for 3 years, but usually 6 years, not 6 months, 6 years. Now you can unpack your stuff and you could make it your home in that sort of time. So, you know, this sounds reasonable. And it's not just France that has that sort of time, but why are we in this country, in England, just 6 months? And they have a wonderful title for dealing with what we call unhealthy housing or unsafe housing. They call them insalubrious dwellings. Wonderful title. Anyway, the procedure they follow is they serve a notice, and as soon as that notice is issued, the tenant is under no obligation to pay rent. Also, the time scale of the tenancy, say it's 6 years, will be suspended, so the time doesn't tick away until the works are completed. Now that's recognising at least that a tenant has some rights and is recognised. There's a different approach in New Zealand. There they use the rating system to inform what they call the Healthy Housing Index. And that was looking at it was more less of an informed approach to the assessment, but more related to a checklist, but nonetheless was based on health principles and trying to, as health and safety principles, and trying to ensure they should be dealt with or identified. From that came what they call a warrant of fitness based on the Healthy Housing Index. And the idea is that the dwelling should be satisfactory at the commencement of a letting. Unfortunately, at the moment, and this is partly to do with attitudes in New Zealand, they don't like regulation and control there as much as, or don't put up with as much as we do. So it's not mandatory yet, this warrant of fitness, but it has been adopted in some areas, and some landlords are content, I think that's a better word than happy, to comply. I mentioned the USA and the American Public Health Association and the basic principles of healthful housing, which is what they produced in 1939. That has been reissued by the CDC, the diseases control section of the US federal government. What happened was the Housing and Urban Development Department of the federal government adopted the rating system unchanged, except for the title. They use the title Healthy Housing Rating System. There was one or two other alterations because there are differences in words, like we may call it a tap to a wash and basin or a bath, they call it a faucet. So one or two terms were changed, but nothing else. Otherwise, the Healthy Housing Rating System was identical to the Housing Health and Safety Rating System. Application and enforcement in the US depends on the state. So there's 52 states, some of them have adopted it as a principle behind assessing housing conditions. And the Housing and Urban Development Department made the Healthy Housing Rating System a condition of any grant that it issues. It issues grants to local authorities, to non-government organisations and so on. So anybody dealing with housing conditions had to adopt the Healthy Housing Rating System. I should also mention that the Housing Health and Safety Rating System only applies in England and Wales. It has not been adopted in Northern Ireland. They still use the 1954 Housing Fitness Standard. Scotland is different again. It has what it calls the Tolerable Standard. I've always thought that's a bit weird. How much will you tolerate? Anyway, sorry, this is an aside. Right, there's more I can talk about any of this if anybody is interested, but just a couple of things. The major point I wanted to bring out was that standards do not ensure safe and healthy housing. The building regulations permit alternating tread stairs. I don't know if you've seen these. So the staircase, you use your left foot on one side and it won't, if your right foot won't fit on that tread. The next step up is the right foot only, so it alternates whatever. They are, to put it mildly, bloody dangerous. But the building regulations say that, yeah, you can do that. And some of the other standards are only applied, a bit like an MOT, they apply at the time, not continuously. They don't look at what could happen in the future, what could deteriorate. One of the things about the rating system, which wasn't apparent immediately when it was being developed, was that the rating system identifies threats to health and it's possible to put a cost to the National Health Service on the health outcome. And the Building Research Establishment used this to estimate the potential cost to the National Health Service. And France has also adapted the rating system to estimate the potential cost of energy inefficient housing. The BRE's documents that started all this was the real cost of poor housing, and they're now estimating it at around 18.6 million per annum, the cost of unhealthy housing, unsafe and unhealthy housing to the National Health Service. The trouble is the two are totally separate. Housing is separate from health in government eyes and at local authority, at local level. I mentioned France, and there is a paper dealing with this, Esrati et al., Fuel Poverty in France, adapting an English methodology to assess health cost implication. So it's looking at energy and efficiency. There are documents on the rating system, the operating guidance, and by the way, that, along with other documents relating to the rating system, including reports on development, so explained how it came to be as it was in the end, was also guidance for landlords and other housing professionals. So all of these reports, including the operating system, were taken down by the government department until it was pointed out that actually the operating system is necessary because it applies. So that is now the only document that's on the government website. The only other thing I'll mention now is the World Health Organization has produced housing and health guidelines. So the issue of health and housing is not only something that we're interested in here in England and Wales, but elsewhere. Okay.
That's brilliant. Thank you very much, David. And perhaps we need to make our next project the Insalubrious Dwellings Bill and make sure we're not paying rent on defective housing. Can I pass on to David Watkinson, please?
Thank you very much, Nick. And that was a difficult couple of people to follow, but I will do my best. So I am going to be talking about the European Social Charter of 1961 and the European Convention on Human Rights from 1950. And I'll speak about the role of these bodies and their enforcement machinery in requiring proper housing conditions and maintaining them. Well, the first question that you might ask is, do these treaties still apply to the United Kingdom since Brexit? And the answer is yes, they do, because the treaties that set them up were entirely different treaties to that which led to the UK joining the European Union. Now I'm going to take the European Social Charter first. It will probably be the main part of what I have to say. The rights guaranteed by the European Social Charter concern health, education, employment, and housing. And it's been described as the social and economic counterpart to the European Convention on Human Rights. And the case I'm going to focus on was a case brought in the enforcement body of the Charter, which is the European Committee of Social Rights. And the case is titled FIDH against ERA. And FIDH stands for International Human Rights Federation. And the decision in this case was given in 1917, just to give you an idea as to the kind of the time scale that international cases operate in. It was actually registered with the committee on the 18th of July 2014. It was found to be admissible as a case in 2015. The decision, in fact, was made in May 2017, but it wasn't published until October 2017. Now, FIDH was is a non-governmental organization, NGO, and they were acting for 3 particular housing estates in Dublin and 1 in Limerick. And the complaint was the landlords of these estates, which were the local authorities, failure to ensure that the housing met lawful standards to a significant degree, failed to carry out adequate inspections, and failed to have any enforcement system, which was a national failure applicable to ERA as a whole. And the kind of conditions we're talking about was sewage invasion, contaminated water, dampness, and mold growth. Now, the complaint was made under a number of articles of the Charter, but the decision focused on one article, and that is Article 16, which required the states which were parties to the Charter to promote the legal and social protection of family life by a number of means, and included in them was the provision of family housing. The conclusion of the committee was that the government had failed to take sufficient and timely measures to ensure the right to housing of an adequate standard for not an insignificant number of families living in local authority housing. And they therefore found a violation of Article 16. There are a number of other articles that are the subject of the complaint, which largely concerned a link with discrimination against public in contrast to public housing in the carrying out of the state, in carrying out of the Republic of Ireland's duties. Those complaints were rejected. They also did not deal with the other complaint that was made, which was a complaint under Article 31 of the Charter, and that provides for a right to housing. And they did not deal with that complaint because ERA had not signed up to that article. And that is a feature of the social charter and its implementation that I'll come back to. But there's another paragraph in the committee's decision, which I think is also worth having a look at. And this is at paragraph 109 of the decision. Incidentally, you can get hold of this decision quite simply by Googling European Social Charter, FIDH of the ERA. It'll come up, but the website that you're after is coe.int, which is obviously standing for Council of Europe International. So in this paragraph, the committee held that Article 16 required that state parties to the Charter should, 1, adopt the necessary legal, financial, and operational means of ensuring steady progress towards achieving the goals laid down by the Charter. 2, maintain meaningful statistics on needs, resources, and results. 3, undertake regular reviews of the impact of these strategies adopted. 4, establish a timetable and not defer indefinitely the deadline to achieving the objectives of each stage. And lastly, pay close attention to the impact of the policies adopted on each of the categories of persons concerned, particularly the vulnerable. Now, as I said, that decision was made in 2017, and the enforcement procedure for the Charter provides that the committee will require the state to make a report every year on the steps that it has taken to bring it in compliance with the Charter. And the committee then issues itself a report setting out what has been reported to it and what its conclusion is as a result. And the most recent report from the committee was this year in March 24th. And the committee considered measures taken by the Irish state since 1917. They looked at preventative maintenance measures taken by the state and local authorities, and a number of regeneration projects that were underway to address the causes of the disadvantages identified to the by the committee. But in the committee's view, the provision of adequate accommodation to a large number of families is still subject to substantial limitations, their quote, and they continue to live in substantial substandard local authority housing conditions. They also considered that the legal framework for right to housing for families in Ireland is insufficient. They observed that there were still no national statistics on conditions of the local authority housing stock. There was no national timetable for the refurbishment of local authority housing stock. The government had not fulfilled its obligation in ensuring community safety for local authority housing tenants. There was no meaningful participation of those affected in the design and implementation of actions taken, the maintenance of housing policies, programs, and strategies. And the legislation permitting evictions has no provision for consultation or for reasonable notice of and information on the eviction. Not always is there provision of alternative accommodation or adequate legal remedies for those evicted, and there is no legal aid for those threatened with eviction. Well, you could write quite a number of those in relation to a number of other states, including state parties to the Charter. And the committee requested a further report from the Republic of Ireland. And you won't be surprised after all that to hear that the committee found that the Republic of Ireland is still not in conformity with Article 16 of the Charter. I should add that a substantial amount of information on the Republic of Ireland's failure to comply had come from another NGO called CAN, C-A-N, which stands for National Action Network, and particularly from their advisor, Professor Padraig Kenna of the University of Galway. Okay, now, well, what application can be made of any of this to the United Kingdom? So going back a bit, the European Social Charter was adopted in 1961 and revised in 1996. The UK signed and ratified the 1961 Charter. It has signed the 1996 revision the year after, 1997, but it has not ratified it, unlike ERA, of course, which has. Now, enforcement of the Charter leads to decisions by the European Committee of Social Rights, as I've been describing. But by an additional protocol, collective complaints of breaches can be made by trade unions or NGOs. However, the United Kingdom has not adopted that protocol. And it is only by NGOs or trade unions or similar organizations that complaints can be made to the committee. The ESC procedure for enforcement does not allow for individuals to have a right to complain of breach to the European Committee. However, were the United Kingdom to ratify or adopt the protocol, then proceedings by an NGO could be taken to enforce the Charter by complaint to the committee. And that could include a complaint under Article 16, because Article 16 was included in the original 1961 treaty. So what has taken place in ERA could more or less at the stroke of a pen become an action which can be taken by a United Kingdom NGO. Okay, I'm going to turn to the ECHR now. I shall deal with this rather more briefly than I've dealt with the European Social Charter. The European Convention on Human Rights, as I guess everybody who's attending this seminar knows, provides for a catalogue of rights which binds the state parties and as well as freedom from torture, freedom of assembly, right to a fair trial. It includes the right to respect to private and family life and the home. That's Article 8 of the Charter. And in addition, Article 1, Protocol 1 provides for the right to enjoyment of property. Both these rights are subject to the proportionality principle, which is basically the court considers whether the harm caused by the breach is outweighed by a number of other factors, amongst which is included the rights and freedom of others, which in the housing context, of course, can refer to landlords. And the enforcement machinery is by complaint to the European Court of Human Rights. However, we might seem a curious anomaly here because organizations, with one or two exceptions, cannot make a complaint to the European Court of Human Rights. Complaint has to be made by individuals. Believe me, people, I do not write this. I didn't create this system. I am simply telling you what it is. For the exceptions that I mentioned to that under Article 25, when NGOs can make complaint, though Article 25 is very specific, and those bodies which are considered to be legal persons can make complaint under Article 1, Protocol 1. In fact, that can include private companies. So that is the situation as to who can make a complaint to the European Court of Human Rights. However, multiple numbers of individuals can make joint complaints to the European Court, and also individuals can raise an issue of general importance. So complaints of breaches affecting groups of individuals can be made in that way. Now, since the coming into force in the United Kingdom of the 1998 Human Rights Act, which was in 2000, the European Convention rights have been directly applicable in the UK. So that actions under the convention can be brought within in our courts. So far as Article 8 is concerned and housing conditions, so far no case, so far as I'm aware, has succeeded in establishing that Article 8 can be breached by failure on the part of public authorities to remedy poor housing cases. However, that is an ongoing piece of work because it is still an issue whether and in what circumstances a public authority could be held in breach of Article 8 of the ECHR. And I'll just make a quote on one of the leading textbooks in this area, which is Housing Conditions, 2019 edition by Jan Loughborough, a circuit judge. He's on a Judge Loughborough, Catherine O'Donnell, and Giles Peaker, who Karen mentioned earlier. And the quote is, "It is possible that in exceptional circumstances, a landlord, which is a public authority, could be in breach of an occupier's right to respect for his or her home under Article 8, where it allowed a property to deteriorate into a very poor condition and could well be attained by a tenant adversely affected by condensation dampness." Now, obviously there could be an overlap between that and the Fitness for Human Habitation Act. But the remedy in our courts would be a claim for damages or compensation and a court order requiring a remedy of the conditions. So there you have it. That is a summary of what international bodies can do in relation to housing conditions. It might seem to you that the enforcement is what you might call soft enforcement, and it is not as clear and more laborious than remedies that can be obtained for a straightforward cause of action in the UK. But the Irish example and possibly ongoing work in the UK show that complaints about housing conditions can get a remedy using the international treaties that I've referred to. Thank you very much, Nick.
Thanks so much, David. That's some really good, inventive international lawyering. And I always think it's amazing how similar the UK and Irish housing crises are. And we've got a lot to learn from each other. I've had 2 or 3 questions in. The first is for David Ormandy, the others are for the panel. And the first one comes from Stephen Hockman QC. And he says, David, you will not remember, but nearly half a century ago, we did some cases together concerning defective rented accommodation. You were the very expert witness. I was the very inexperienced advocate. Do you think that in general terms, rented housing standards today are any better than they were then? Well, we may have to get you unmuted, I'm afraid. Sorry, Joe.
No, I don't think they are any. I think houses are deteriorated. Buy to let encourage people to get houses without any experience and let them without any knowledge of the legislation, the obligations that they had. And because of various things, why spend money on a house to improve it for the benefit of the tenants? If you do, you want to raise the rent. That's not easy. So the answer, straightforward answer is no.
Thanks for that, David. The next question comes from Rob Sale, who's a very experienced environmental health officer. And what he's saying is that there's a problem in the UK with underlying poor building standards and deregulation in construction. And I think we're seeing that particularly with the Grenfell inquiry. And should our approach to enforcement be looking more at that, at a more sort of prevention is better than cure approach? Can I ask Karen to come in first, please?
Prevention is always better than cure. So, I mean, in a sense, yes, of course, that's right. But I think for the reasons that we just heard in the last question, I don't think it's going to be enough, and certainly not in the private rented sector, because I think different factors are going to be pushing us in the opposite direction all of the time. I kind of made reference to the fact that the PRS, I mean, you could look at this both ways. So, I can answer this question yes and no at the same time. But the fact that there are people now in the private rented sector at scale who were not in the private rented sector 20 years ago, or their equivalents were not in the private rented sector 20 years ago, and they shouldn't be in the private rented sector. So families with children, people on low incomes, people with disabilities, people with vulnerabilities, older people, by and large, some exceptions, of course, some people will always make these choices for different reasons, but by and large, the private sector is not suited to them for a whole host of reasons. A full package of renters reform legislation would help with security of tenure, but I suspect their lack of meaningful power, even in a better world with more lawyers, make of that what you will, but yeah, they are always going to be at risk. And so, I think a wholly prevention-based strategy is a great theory, but probably won't work in practice. And so the answer, as always, perfect politician answer is that, I mean, you need, you've got to have the range. You've got to have you've got to have a preventive approach. That preventive approach would include, for me, housing a much larger proportion of people currently in the risky and unsuitable private rented sector in a modern version of social housing in all its manifestations, and giving power, advocacy, advice and representation to people to enforce when they are in the private rented sector, and indeed in the social sector, because as the ITV research that's been running for the last 2 or 3 weeks has shown, poor Croydon, it could have been my borough in Westminster, local authority housing and some housing association property is deeply unfit, whether that's because the traditional, mold and black ceilings unfit, or fire safety unfit, but they are unfit. So I think you're going to need all. But a prevention, a kind of exclusively prevention-based strategy, I think, is doomed to fail.
David Ormandy. Joe, would you mind unmuting?
Sorry. I just mentioned again the New Zealand approach of a warrant of fitness, that the dwelling is fit for letting, for occupation at the commencement of the letting. That was it.
Thanks. David Watkinson, did you want to come in on this?
Yes, just recall what David said in the course of his contribution. One of the criticisms of the health and safety standards that we have at the moment is they deal with present conditions rather than how conditions are likely to develop. So I think there is some scope there, I don't know if David would agree, for amendment or development of the current standards to deal with how forecasting how a condition might develop and for provision for a notice requiring that to be remedied. And I see David has his hand up, so I'll pass back to him.
It was only that I agree. One of the things in the rating system is to assess the condition having regard to what it will be like in 1 year. Now, that's a fairly short period of time, but assessing what will happen in 5 years is very difficult and difficult to justify. I agree with you, David, but it is not an easy thing to solve.
Thanks. Something Karen touched on, and there's another question about it, is whether we've been talking about private sector enforcement, but do we need to now be just as worried about conditions in social housing? Looking particularly at the report that came out on Croydon this week, where it seems that chronic underfunding means that there is just a woeful lack of staff and some very, very troubling attitudes. And are we sitting on a time bomb there? Karen, did you want to come in first?
Yeah. I mean, I think that that we are seeing now the kind of complete unspooling of the Decent Homes Initiative. So that that now is is working its way through. I mean, I'd be very interested to hear some audience responses on this. You can't you can't always and exclusively put. Well, resources are kind of at the root of this, they are, but it's also true that again, not all local authorities are, have the kind of political will and drive to deal with this in different ways. And as we've referred to in the past, and the tenants in low-income tenants in the private rented sector and many tenants in the social housing sector are for different reasons. People who need support in exercising their rights, and they have strong views and great capabilities, but not necessarily to be able to act and enforce for themselves when conditions are poor. And I think they're kind of, I mean, I've spent a lot of time kind of going around this course in different capacities, but the kind of tenant voice models that successive governments come up with seem to me to be almost always to fail. And we do, the representative tenant organisations are deeply flawed, and we need to kind of think of new ways of dealing with that. Incidentally, one kind of huge subsection of this, which I see all of the time, is the near impossibility for poor bloody local authorities to handle conditions, mostly disrepair, where you are in a mixed tenure development, and particularly mixed tenure multi-storey, because the worst problems that I experience at scale is when tenant A is suffering from, say, water pouring through the ceiling from leaseholder B. That's very hard. And just the last point on this, when the Fitness for Human Habitation legislation was in draft, and we met with the NatFed to discuss concerns that the social housing sector had about the fitness legislation, and were told and reassured that that sector would be doing a proper audit of conditions in housing association property. Don't know what happened to that, but I haven't seen much sign of it. So I think we're going to have to kind of go back to that one.
Thanks, David Ormondy.
Just 2 points on this. One is that there was a case, Cardiff against, who was it, Cross, which is where an occupier of a house owned by the local authority was complaining about the conditions, quite rightly. They went to the court, and it went to the High Court, and it was held that a local authority cannot take action against itself, which is means that all social housing, all council-owned housing, is excluded from the rating system enforcement procedure. It can apply to housing associations because they are not council owned. So a local authority could take action against housing associations, but tends not to. That was the main point. The other point is that there is a difference in the tenancy agreement with social housing and private rented sector. And there were several cases taken under legislation under what became the Environmental Protection Act, dealing with condensation, dampness, and other aspects of unhealthy housing. That has now become virtually unavailable, not because they've changed the law, but you don't get legal aid to take a criminal case against somebody else. And it would be a criminal case. They were quite successful initially against local authorities, although local authorities wanted an exemption put into the legislation so they couldn't be prosecuted. And I still think that you've got to come up with some procedure, some method, some arrangement for inspection of local authority housing to enforce standards.
Thanks. Rob Sale, who asked the question and is an EHO, asked if he could make a quick contribution. So I'm just going to allow him to talk, if you'll bear with me. Rob, do you want to go ahead when you're ready? While we're waiting for him to unmute, David Watkinson, did you want to come in on that last point?
So does that better?
That's better. Thanks, Rob. Go ahead.
Sorry, Nick. Yes. On, I mean, just a couple quickly on the point about that I made. I think in an email that I wrote to the speakers. I was really looking forward to this because I think it's very important, everything that's coming up, and we've got some experts here. The point that I was making about the preventative case, again, learning from the other countries, is that I know that one of the things that will probably come out of the Grenfell inquiry and is well known not just in cases of fire, but is in cases of all sorts of other refit situations with housing, is the unaccountable nature of the design and build, particularly development system we have in this country, which is, I mean, you know, overwhelmingly to do with profit before people. And it transpires that there are situations in Germany, in France, and I think in Ireland, I understand, where they have a legally designated architect who is responsible to stop this farming out of responsibility down the line with subcontracting. Now, I think it's the case that there is an enormous amount of lobbying probably going on from that industry to stop that change being brought in here. Well, that says to me, no brainer. That's what we need to do. Now, I think that, you know, I'm no expert on this, but I think that needs looking into. And as far as the damp and mold thing is concerned, I mean, what I've learned from, I have been an EHO, and a lot of my values in terms of being an EHO were formed early on when I was a community worker and then a vice worker in Lambeth. And I met people like David Watkinson and Dave Ormandy doing what they did then, which was working with tenants organisations like the Loughborough State Tenants Action Group to hold the state and the system to account. Not attacking the people, that brings about change. I mean, I've had a little bit to do with our political system. There's great people in it. One of them's here. But that system does not bring about the sort of changes that people have been talking about here. I mean, and the things we remember are the things that we heard from those people. Like, for instance, the one I put in the chat about the woman who was talking about the overheating complaint. I never thought overheating was a problem in this country until I went down to this estate on the Vauxhall Bridge Road. Karen will know it. And they were telling us to open a window at night to keep it warm if it was too hot. And she said, you try getting to sleep when your pillow's 20 feet away from the edge of the Vauxhall Bridge Road. Now, I know plenty of people who have got as much technical expertise as the people in this room, and that's a praising of them, not a running down of you guys. That is the kind of thing, if you meet, that's the thing that keeps in people's minds. And I think there will be people in this meeting who are with groups like the London Renters Union and other renters unions from up and down the country and so on. And that case in Ireland shows so much that those values that were encapsulated by the work that was being done in the 80s, and I'm not a good old days person, there's loads of it going on now, but we mustn't forget this in terms of bringing about real change. We cannot rely on the centrist sort of little, system, which is all about prioritizing profit above people. And we can bring about real change, working with people, working with groups like they did in Ireland. I mean, they held the state to account. I couldn't believe it. My wife's Irish. We went there once and I heard this woman on the news at Christmas time saying, well, I live in this place, it's covered in damp and mold, and they've been telling me for years it's because I've got too many, I haven't got any saucepan lids. I thought, bloody hell, what's this? This is the main news. And I went and visited the people. And what we need to do is link up with people like that, link up with our community groups and so on, and learn and take action. And I feel that strongly, and I'm going to say that's enough. But
thanks so much, Rob. Does anyone want to come back on that before I wrap up? Karen and then David Ormondy. Sorry, Karen, did you want to go first?
I'll just look. Of course I agree with that. I think that there has to be, individual power, local power, the strength in the civic institutions, and the fact that local government has been stripped not just of resources but of the kind of local pride that draws people into it with a passion and an ability to make a difference at a local level. I mean, it is a tragedy, and one that can be reversed into a certain extent. Some of the mayoralties are helping to do that, and that's terrific. But I suppose ultimately, and perhaps, this is the right place to be saying this, you need the law. You need the law, because a proliferation of local organisations and renters unions and, and the slightly arbitrary nature of whether there's going to be people there with the time, the energy and the skill set to make things work is not going to be enough. It didn't work in North Kensington. It just didn't. And North Kensington, which I used to represent and know very well, probably had a better and stronger civic society network than most places. I think, most places. It was good. It still is good, actually. It's got a really strong, it's fairly small. It's got a powerful voluntary sector, and yet that wasn't enough. So, keeping hold of the law as well as individual and community action, I think, is kind of incredibly important.
Thanks, David Ormondy.
Just a couple of points there on the prevention and the design and construction of dwellings. There's two aspects to this. One is that the building regulations are, to my view anyway, inadequate, and their approach is inadequate. I'm not sure I'm supposed to say this, but when we were developing the housing health and safety rating system, we tried to involve the building regulation people in part of that department, and they weren't interested. So their approach is still very much building orientated and doesn't always prevent some of the problems. Rob Sale mentioned overheating, and that's one of the problems that is covered by the rating system, but not applicable necessarily to council or public sector housing. And the BRE have produced documents on overheating in dwellings, explaining why and explaining how to assess. So that exists. The other thing really is legal aid, where, it's just gone. And there should be, a final thing, there should be an arrangement for the application to deal with unsatisfactory public housing.
Thanks. Legal aid's not gone. We're still here, but I take the point that it's not what it used to be. David, David Watkinson, did you want to have the last word?
Yes, thanks, Nick. Just quickly, local authority time bomb, certainly goes back decades, and ever since public investment in housing was cut by 2/3 in the early 1980s by the Thatcher government, that has left a legacy with which we've been grappling with ever since, and has not been restored, indeed has been reduced even further. And I have very fond memories of the Loughborough estate campaign that Rob mentioned. David was involved in it as well. It was part of what made me a strong believer in the combination of organisation on the ground, professional help, and Parliament as the means of making progress. And when I talk of strong activity on the ground, I'm reminded of the time when the chair of the Tenants Association gave her evidence in court. She was one very forceful lady, and at the end of my examination of her, the council representative got up and said to the magistrates, "Gentlemen, lady," said, "I would not dare cross-examine Mrs. X." And that's the kind of spirit that gets us through.
Great, thanks, David. Well, as Rob said, this has been a really, really expert panel, and I'm so glad and grateful to them that we managed to bring you all together. And it's been a really useful and interesting session. So thank you very much indeed to the panelists. Thank you to Joe for doing the tech. And please do keep an eye out for our upcoming webinars. We're likely to be discussing the end of the eviction ban fairly soon. We'll circulate the date, and we've got more webinars planned over the summer. If you'd like to get involved with the housing subgroup or any of the other SLR subgroups, please do drop us a line. And otherwise, thank you so much for coming, and have a lovely evening.